And Martin's got some homework to do. Now, we do have to have a quick special session. We have to get the table, so it's now 4:05. We'll open the special session. Please stand.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, liberty and justice for all.
The only thing we have to do about that is you report.
Yeah.
Pay, please.
It took, I think it was yesterday or the day before to get through to her. And we chatted. It was interesting. She told me she had spoken with Stump about and tried to bring up these issues. And he basically told her, I don't care. I don't want to hear from you about this. I'm not interested. End of conversation. And I really, if she's listening on YouTube or wherever you listen to this from, I hope I characterize that correctly. And then I asked her, what do you think? Well, I'm not the attorney of record. I haven't been asked to render an opinion. So that went nowhere, although she did say she was against abandonment generally. I asked her about the real party in interest, and she couldn't comment because she wasn't the attorney of record. And I thought those were all pretty weak excuses. I'll put it that way. So that, that was no help. Now, I do want to report this, though. In the lawsuit, Woodley even states, and I'll read you the actual verbiage. In his complaint, or well, it's a petition because it's a matter of equity rather than at law. So he states that plaintiff, which he should have nominated himself petitioner, recorded with the county recorder a warranty deed deeding half of Cracker Street running parallel to the west side of his property and Auburn Street running parallel to the south side of his property to Myron Woodley, trustee of the Myron Woodley Revocable Trust. That's right there in his lawsuit. Okay? And then he says later on in his, he goes on, and this is in his prayer. The prayer is where he says, wherefore I want judgment against you for $1 gazillion. Plaintiff recorded with the county recorder a quitclaim deeding the intersection of Center Street and Auburn Street to Miners Exchange MC Woodley's DBA. Okay. Then in his amended petition, which supplants the first one, however, everything said in a court filed document is a judicial admission. That means you've admitted it for the sake of the lawsuit. Okay? So what he does here is he says petitioner has standing to request the relief because of his legal rights and status to the intersection of Center Street and Auburn Street are affected. All right. He says that in the name of Myron Woodley, but then he says he's recorded a quitclaim deed to Miners Exchange, and then he says plaintiff recorded with the county recorder a warranty deed deeding half of Cracker Street, running parallel to the west side of Auburn Street, running parallel to the south of his property to Myron Woodley, trustee. Now he's admitting the trustee gives him his status, yet it's in his name. And, you know, I guess to me it makes sense. Maybe that's because I made the mistake of going to law school. But then we have okay. Section 20, or I can't see worth the darn anymore. 38 of our charter states the procedure for making, altering, vacating, or abandoning a public improvement shall be governed by general ordinance, or to the extent not so governed by the applicable general laws of the state. You know, I'm assuming we didn't have a vacation ordinance at that time, but we do now. And this charter's in effect. And then there's also state laws regarding vacation and abandonment. In common law, abandonment is not favored. So there we are. The question is, do we settle with Woodley and save a bunch of money, or do we insist he bring it in the proper party and try to get the abandonment changed to a vacation? Because he says also in his lawsuit it's deemed abandoned or vacated, which in the way he puts it is very interesting. Let me see. Let me get back to that one. All right. He says that the road is a legal, the state of legal existence. It changed from that to non-existence. Didn't exist legally. I guess the land went poof and disappeared. Maybe that's where black holes come from. Anyway, what the upshot of that is, it says it doesn't exist. So who owns it? If we abandon it, who owns it? Do we own it? Does Myron own it? Do I have a right to own it? I'm a citizen of Sumter. So that's the question. So now we get back to, I guess, the $64 question, and that is, are we going to settle this just to get it out of, or are we going to do it right? And I know what I'm in favor of doing, and that is doing it right, if we're going to do anything.
But we don't have the money to go to court with him.
Then we fire him and get someone we can't go to court with.
That's still going to be $30,000 or $40,000, isn't it?
Well, I don't think so, but then, what do I know? So, my position. I have checked with Page, who would not render an opinion. I told you I checked with a lawyer who does nothing about trusts, a lawyer who does nothing but tax matters with trusts, and the trust is the proper party. Woodley admits that basically in his pleading, which was inartfully drafted. But, here we are.
Yeah, and the last communication we had to Stump was to have it changed into the trust.
Okay, but then you still gonna abandon it? See, he never responded. When I said, you can't abandon this, here are some cases, actual reported cases that any lawyer can look up and read what the Court of Appeals or Supreme Court of Oregon said. Did I hear back anything? No.
That's what you said at the last meeting.
So, you know,
Well, I mean, we're kind of to the point, yes, we need to make a decision whether we're going to just sell, as we talked about doing in January, and let it go away, or if we're going to end up going to court, because he's not going to, we already, I think he was approached as a vacate, and he would not do it. So,
maybe he figured it out finally.
The thing is, though, is,
but we have to go one way or the other, we can't just,
the thing is, though, is if you try, if you don't accept it for the way that it was written, totally. Myron, he's already said, Myron said that he ain't gonna,
so
it's
basically,
nil and void.
And so we have basically spent over $100,000 of money that is taken from the citizens of this city on legal counsel.
They should have been fired.
Well, it should have never been hired.
And it was closer to
But
two
we
hundred.
have, we have already
Yeah,
spent the
right.
I
money.
think there were several attorneys in office over the years, I believe.
There's a can of worms too. You have a public that will jump on the opportunity to then, the city can't defend their streets, here we go, you're gonna lose.
Yeah.
them.
But we could also wind up
The thing-
filing bankruptcy over the whole deal too. So where does that get us as far
And
as
see,
the
and part of it,
citizens?
for what you're talking about, Rebecca, is in the part of the lawsuit stating that this is a very, very rare one-time circumstance. This is not to set precedents.
That binds the city of Sumter and it binds Woodley. So Woodley cannot use it again for any of the other properties he has bordering any streets. Anybody else can, like Marcia has land down there, could say you did this here. Now, whether that flies or not, I don't know. I'm not a judge.
So then for that statement that's put in there is just for
Woodley.
Woodley only.
Because we could see him wanting to do that with other streets that border his property. That's something I thought about when I asked him, or asked for that.
His whole thing is, I showed you a picture of the street. It has existed. Cracker, Auburn, and Center all existed. They were the thoroughfares to the railroad. They were roads before Marsh's was a property and Woodley's was a property. It was just a big railroad area. And after 1895, probably around 1830, they split them up into properties because they didn't need the railroad anymore.
Well, the thing is, this has been kicked around, so we need to decide which way we're gonna go. If we're not, if we're going to just tell him, no, it has to be, this has to be changed, that has to be changed.
Well, if we're
Are we
gonna, if,
prepared to go to court?
the thing is, though, is if we're gonna do that, I think that we need to get rid of some, and we need to get another attorney.
I'm tired of spending money on Myron Woodley. Totally.
Well,
If Martin hasn't come into the picture, we have a lawyer that we have spent a tremendous amount of money on that has guided us in this. I mean, Martin brings up valid points. We can have another lawyer bring up valid points. I tend to look at the citizens of the town, over the $100,000 that we have spent on 10,000 square feet of road, that money would benefit the city, the 95% of the citizens of the city a whole lot better than a road. They could have equipment. They're worried about sewer, water, and the roads being plowed. We don't have the money. And if we go to court again, we're gonna be bankrupt.
It's not gonna matter.
I make a motion that we not settle under these terms. You can let it die for a second or do what you want.
I'll second it.
Where that's gonna go.
Because it's one of those things where we need to, it needs to be done and done right. And we've come this far and we spent this much money, and that's our own.
Okay, well, we have a motion on the table.
Can I ask a question first? Before you do the vote?
Sure.
Can I ask this? Marcia, do you have a conflict of interest with this? Because that land is right close to yours.
I do not border that piece of property in any way, shape, or form.
I just wanted to find out because you would be voting on this.
Yes, I realize that. I could vote with the potential that it could be a conflict of interest. He is a neighbor. I do not border that property in any way. I'm on the whole other side.
Gotcha.
But to use this as precedent,
Why would I do that?
I don't know.
It's,
Okay, we've got a motion on it, so all in favor? No opposed?
No.
No, too. So we're
It
now,
does not pass.
does not pass.
Okay,
And so we are back to the same. I mean, I guess we'll just see. I think we're gonna end up going to court on this because,
And I don't wanna do it with some.
well, so the first thing is we have to have Myron come back and tell us, no, he's not gonna do it.
So,
And once
Well,
he
then-
does, then we'll go from there.
so then we can take it and put it. I guess I can make the motion if it needs to be, but the thing is though, right now, we're just saying that if we take the information we got and you try to get verbiage changed, try to go to a vacate, try to get the
Trust.
trust right, and if Myron doesn't wanna play that game, then I said, then you're back to square one where you're gonna get rid of something, you're gonna go the other direction.
That's what it goes.
That's what it's
So
gonna
then therefore, then I can make a motion that we send them to Myron's attorney or ours to send us some for that time being to do, to change the abandonment into a vacate and then also to do,
Trust.
the trust change.
Plaintiff trust. Okay,
is that a motion to fire Stump also?
well, don't we need to have this kicked back at us first?
I believe so. I think it's premature to fire.
Right,
Right.
no, I'm just gonna go back and say we want plaintiff to show the trust and we want the abandonment to show a vacate.
And if Myron comes back and says
And
no,
once he
then,
comes back, then we can address the next.
so that's the
Maybe,
motion.
maybe he'll go apoplectic.
The motion on the table. Do I have a second?
I'll second that.
Okay. All in favor?
Aye.
Opposed?
The two of you are opposing?
No,
Oh,
no, we
no.
gotta move forward. I mean,
We
we
gotta do it one
cannot
way or the
keep kicking this can down the road.
I know.
So
We
if
gotta
we-
move forward.
If we don't see it through, he's gonna sue us again. Dust abatement, he has bad lungs, the AT Green Bridge, I don't know, I don't even care, but he's already got 3 lines lined up, so.
Well, we can't
If
worry
you-
about what's coming up.
He'll sue
Well,
us
it's, I'm
until he
saying if you
dies.
settle with it, you blew 200 grand, and now here we go, get another flagrant lawsuit. You spent 200 grand on attorneys for a street that never exists, and I got a picture of it.
Or the potential.
You know, I mean-
Ten more lawsuits.
We're taking the vote. Everybody loves to sue the city, so we'll just go from there.
I got a question of
I'm
John.
not trying to change the vote, I'm just trying to let you know.
Yeah,
Yes, sir. Yes, Martin?
we know we've spent money. We know how Stump got here. And we know he has not done a good job and he has not been responsive. Okay? But that's no reason to roll over and play dead. And Myron's gonna sue us, he's gonna sue us anyway, even if we settle this one. He said he would.
That's what I just said.
Okay, and so if he does, then maybe we'll have an attorney with the cojones to go for sanctions against him.
Yeah.
Or someone will step on his hose. Oh, sorry.
Be nice.
I'm just concerned that by settling, you invite 10 more different
Yeah.
citizens to jump on the city's vulnerability and sue you for the streets in their property.
It's just a what if, I mean, we
Well,
can,
the
I mean, if
thing,
we
We're not
don't settle, if we don't settle,
We're damned if we do and
yeah,
damned if we don't.
yeah,
the thing is
either way,
though,
they're gonna get us.
motions.
Well, the thing is, though, is, as Rebecca is saying, this is where I thought that clause, the way that I was explained to, says that sets precedence against anybody else. But then Martin says, no, it only does mine. So therefore, I was misled in this because I believe it was a one-time shot. This is a one-time unique situation, and therefore it doesn't set precedence or whatever it's called, for anybody else Who is- in the general public to do this.
So we have made the motion to do what we've done.
Yep.
So I make a motion to adjourn the meeting.
Second,
All in favor?
Aye.
Renee?
you know, we're damned if we do and damned if
Oh, yeah.
we don't. And as much as I disagree with the three of you on virtually everything in the universe, in this